This panel is for practicing attorneys and sitting judges, young lady. The student mixer is down the hall." The words hit like a slap, delivered with the casual cruelty of a man who had already decided what he was looking at, and dismissed it. The conference room at Whitfield Law School held 40 chairs, mahogany walls, portraits of distinguished alumni stretching back a century, and one man in a tailored charcoal suit blocking the doorway, his state judicial pin catching the overhead light. He was wrong about everything. The woman in the simple cardigan and flats was not a student. She was not lost, and she sat on the federal appellate court that reviewed every ruling he had ever made. She held a registration printout. VIP seating, row A. The confirmation was dated 3 weeks ago. "I'm registered." Her voice stayed level. "Row A." He looked at the paper, then back at her face. Something shifted behind his eyes. Not recognition. Calculation. The quick arithmetic of a man who trusted his instincts more than documentation. Registration errors happen. He stepped closer, close enough that she could smell his cologne. Sandalwood. Expensive. "I'm sure you understand." Behind him, a woman with a faculty lanyard watched the exchange, said nothing, did nothing. "The confirmation has my name, the date, the seating assignment." And yet, he smiled, the smile of someone who had never been wrong in a room full of people who depended on his approval. "Here we are." He turned his back. The faculty woman followed. The door clicked shut. Naomi Vance stood alone in the hallway, holding proof that meant nothing to people who had already decided what they saw. If this satisfies your soul, subscribe now. This satisfies mine. 48 hours earlier, the drive from Richmond had taken just under 2 hours. Naomi pulled her Honda Accord into the Whitfield Law School visitor lot at 10:14 a.m. on a Friday in mid-September. The campus looked smaller than she remembered, 20 years since graduation. The Gothic Revival building still stood, stone and ambition frozen in architectural form, but the trees had grown, softening edges that once felt sharp. She checked her phone. 3 emails from her clerk about pending cases. 1 text from her sister asking about Sunday dinner. She silenced the notifications, placed the phone face down on the passenger seat, and sat for a moment. Alumni weekend. The invitation had arrived 2 months ago, a thick cream envelope with the law school's embossed seal. VIP registration for the Judicial Ethics Symposium. Her name in calligraphy. Class of 2004. 20 years. She had almost declined. Federal appellate judges did not have weekends, not really. There was always another brief, another oral argument to prepare for, another dissent to write. But something about the invitation had pulled at her. Nostalgia, perhaps, or curiosity about who she had been before the bench, before the robe, before the weight of deciding other people's fates. She grabbed her canvas bag from the back seat, worn at the corners, comfortable, and headed toward the alumni lodge. The registration tent stood outside the main hall. A young man in a navy blazer sat behind a folding table, tablet in hand. His badge read, Fletcher Holt, Dean's assistant. Name? Naomi Vance. He tapped the screen, frowned, tapped again. Vance. Vance. His finger scrolled. I don't see you on the VIP list. I received confirmation 3 weeks ago. Email from the dean's office. Must be a system glitch. He did not look up. I can put you with general admission. Section C? She could have argued. Could have shown him the email on her phone, the confirmation number, the seating assignment. But she had learned long ago that some battles were not worth the energy, not when the person across from you had already decided you were the problem. Fine. He printed a badge. General admission. No VIP designation. She clipped it to her cardigan and turned toward the main building. Behind her, a woman in pearls approached the table. Blonde, mid-50s. Designer bag. Charlotte Winslow, class of 92. Ms. Winslow. Yes, here you are. VIP, row A. Let me get you the welcome packet. Naomi kept walking. The campus paths wound between buildings she half remembered. The library where she had spent countless nights. The courtyard where she had eaten lunch between classes, always alone, always reading. The moot court hall where she had argued her first fake case and felt, for the first time, like she might actually belong in this world. A campus security vehicle slowed beside her. "Ma'am." She turned. The driver leaned out, a thick-necked man in a gray uniform. Bruno Caffey, chief of campus security, according to the embroidered patch on his chest. "Can I help you find something?" "Just walking to the library." "Libraries for registered attendees." His eyes moved to her badge, then to her face, then back to the badge. "You have credentials?" She held up the badge. He examined it. Far longer than necessary. "General admission doesn't include library access until 4 p.m. She pulled the printed schedule from her bag. "Library opens at noon for all registrants. It's 11:45. He squinted at the paper. She watched him read, watched him realize he was wrong, waited for the apology that would not come. "Huh, must have changed." He put the vehicle in gear. "Go ahead." "No, sorry. No, my mistake. Just the casual dismissal of someone who had never been questioned and did not intend to start now." The vehicle pulled away slowly. She felt his eyes on her back until she reached the library doors. Inside, the reading room smelled like old books and lemon polish. Naomi found a quiet corner, a table near the tall windows where afternoon light fell in long rectangles across the hardwood floor. She opened her bag, removed a leather portfolio, worn but well-maintained. Inside, documents organized with colored tabs, yellow for pending cases, blue for research, green for personal. She flipped to a blank page on her yellow legal pad and began reviewing her notes for tomorrow's panel. Footsteps approached. A woman in her 50s, silver hair pulled back, faculty lanyard swinging. Professor Priscilla Vane, faculty coordinator. "Excuse me." Naomi looked up. "These tables are reserved for panelists and distinguished guests. I'll move if someone needs the space." "It's not about need." The woman's smile did not reach her eyes. "It's about protocol, you understand." She understood perfectly. The woman saw the general admission badge, the canvas bag, the simple cardigan, and made her calculations. Naomi gathered her materials, did not argue, did not mention that she had been on more panels than this woman had organized, had written opinions that were studied in law schools across the country, had sat in judgment over cases that shaped constitutional law. She found a different table, smaller, near the exit, further from the light. An hour passed. Then 2. Naomi worked through her notes, occasionally glancing up to observe the room. Faculty members came and went. Students huddled in study groups. Alumni in expensive suits laughed too loudly, performing reunion for an audience that was not watching. At 3:15, a familiar voice cut through the quiet. "The acoustics in these old halls, dreadful. Cyrus, remind me to request a microphone." She looked up. Judge Kingsley Mercer, the man from the conference room doorway, strode through the library with a younger man at his heels. The younger man carried a leather briefcase and the harried expression of a clerk who had learned that survival meant anticipating his boss's needs before they were spoken. "I'll make a note, Your Honor." "Good. And confirm my lunch reservation for tomorrow. The faculty club, not that cafeteria nonsense." "Already confirmed. 12:30, corner table." They passed within 10 feet of Naomi's table. Mercer's eyes swept the room, cataloging, assessing, dismissing. They passed over her without pause. She was furniture, background, nothing. But she watched him, noted the way he walked, chest forward, shoulders back, occupying space like a man who had never been asked to make room for anyone else. Noted the way his clerk stayed 2 steps behind, never beside. Noted the state judicial pin on his lapel, polished to a gleam. 17 years on the bench. That was what the invitation had said. Judge Kingsley Mercer, class of '89, keynote speaker for the Judicial Ethics Symposium. Benefactor. Legacy. The name on the east wing. She returned to her notes. The evening reception began at 6. Naomi arrived at 6:15, deliberately late, hoping to avoid the awkward minglings of people who did not know her name and would not remember her face. The lecture hall buzzed with conversation. Wine glasses clinked. Laughter rose and fell in predictable waves. She found a corner near the back, accepted a glass of sparkling water from a passing server, and observed. Mercer held court near the podium. A circle of admirers, faculty, alumni, local attorneys, hung on his words. His voice carried across the room, loud enough to be heard, casual enough to suggest he did not care who was listening. The problem with young lawyers today, he was saying, is that they think reading cases makes them experts. It doesn't. It makes them dangerous. You can't learn judgment from a book. You learn it on the bench, in the courtroom, making decisions that matter. Heads nodded. Someone laughed at something that was not funny. Naomi sipped her water. At 7, the room began to thin. Guests drifted toward dinner reservations, toward hotel rooms, toward the comfortable exhaustion of a day spent performing success. Naomi remained, waiting for the crowd to clear before reviewing the lecture hall where tomorrow's panel would convene. By 7:20, the hall was nearly empty. She approached the podium, examined the seating chart posted on the wall. Row A, seats 1 through 12, reserved for VIP guests. Her name was not on the list. "Are you with facilities?" She turned. Mercer stood in the doorway, his clerk Cyrus behind him. "The podium needs to be moved 6 inches left." "I'm not with facilities." His eyebrows rose, a small movement, but she caught it. The quick recalibration of a man who had made an assumption and was not sure whether to correct it or double down. "Then why are you here? This area is being prepared for tomorrow's panel." "I'm reviewing the room, standard practice before any proceeding." The word hung in the air. Proceeding. She had used it deliberately, without thinking, the vocabulary of her daily life slipping into a context where it did not belong. Mercer's eyes narrowed. "Proceeding," he smiled. "That's charming. Are you a 1L playing judge for mock trial?" Behind him, Cyrus smirked. "Maybe she's preparing her audition for moot court." "Listen, sweetheart." Mercer stepped closer. Close enough that she could smell the wine on his breath, the sandalwood cologne that had not faded. "I've been on the bench 17 years. I can spot a law student from across the quad. Run along." She did not move. Instead, she turned to the wall behind him, the laminated conference policy posted beside the seating chart. "Per Whitfield Conference Policy, Section 4.2. She read aloud, her voice flat, without inflection. "All registered attendees may access panel venues during posted hours for preparation purposes. Posted hours are 5 p.m. to 9 p.m. It's 7:25. Silence. Mercer's face darkened. A vein pulsed at his temple. "Did you just cite room policy at me? I read what's posted on the wall. Behind you." He did not turn to look. Cyrus did, saw the laminated sheet, saw the words she had quoted. His smirk faltered. "I don't know what game you're playing." Mercer's voice had dropped, cold now, dangerous. "But I'll be speaking to the dean about students who don't know their place." He stalked out. Cyrus followed, glancing back once with an expression she could not read. Naomi remained at the podium. Her hands were steady. Her heartbeat was not. This is just the start. Like and subscribe. Things get much worse. The registration desk was closing when she arrived. Fletcher Holt was packing his tablet into a messenger bag. "I'd like to file a complaint." He looked up, recognized her, the woman from this morning, the one with the system glitch. A complaint about who? Judge Kingsley Mercer. He was inappropriate and dismissive in the lecture hall. Fletcher's expression shifted. Sympathy and caution, carefully balanced. "Judge Mercer. He's our keynote. Are you sure you didn't misunderstand something? He called me sweetheart. He told me to run along. He threatened to report me to the dean for existing in a public space during posted hours. That sounds frustrating. The words were smooth, practiced, the verbal equivalent of a pat on the head. But Judge Mercer is, well, he's old school. I'm sure he didn't mean anything by it. Why don't you sleep on it? See how you feel in the morning. I'd like the formal complaint form. He began packing faster. We don't really have a form for personality conflicts, but I can mention it to Professor Vane if you'd like. Professor Vane, the woman who had told her she did not belong at the reserved tables. I'll put it in writing myself. She walked away. Behind her, she heard Fletcher pick up his phone. The lodge room was small, but clean. Naomi unpacked methodically, toiletries aligned on the bathroom counter, clothes sorted by day, the leather portfolio placed squarely on the desk. Inside, her documents remained organized with colored tabs. She added a new section, Red for the weekend. She opened her laptop, typed, Formal complaint regarding conduct of Judge Kingsley, Mercer. Date, Friday, September 13, 2024. Location, Whitfield Law School, Lecture Hall. At approximately 7:25 p.m., Judge Kingsley Mercer approached me in Lecture Hall B, where I was reviewing the room as a registered attendee. His behavior included 1. Assuming I was a facilities worker without asking my identity. 2. Dismissing my stated purpose and ordering me to leave. 3. Using patronizing language, sweetheart, run along. 4. Threatening to report me to the dean for being in a space I was entitled to access. 5. Ignoring posted conference policy when I cited it, I am filing this complaint for documentation purposes and request acknowledgement of receipt. She printed the document, signed it, photographed it with her phone, slipped the original into her portfolio. Tomorrow, she would hand-deliver it to the dean's office. Tonight, she would sleep, or try to. Saturday morning, 7 a.m. Naomi's phone alarm pulled her from a restless sleep. She showered, dressed in her simplest clothes, gray slacks, white blouse, flat shoes, and headed to the breakfast hall. The morning was crisp, the sky a pale blue that promised warmth by afternoon. The hall was already filling when she arrived. Alumni in polo shirts bearing their graduation years. Faculty in blazers and sensible shoes. Students serving as volunteers, identifiable by their matching lanyards. She got coffee, found a table near the window, opened her legal pad. The first interruption came before she finished her first sip. Ms. Vance, isn't it? Professor Priscilla Vane stood beside her table. Her smile was fixed, her eyes hard. I heard there was some unpleasantness last night, with Judge Mercer. I filed a written complaint this morning. Yes, I saw that. Vane sat without being invited. Here's the thing. Judge Mercer is a benefactor, class of '89. His family donated the East Wing. I'm aware of the building plaques. Then you understand why we need to handle this delicately. She leaned closer, lowering her voice. Perhaps you'd consider rephrasing? Withdrawing the formal language? Naomi set down her coffee. What I wrote is accurate. Accurate and appropriate aren't always the same thing. Vane's hand reached across the table, patted Naomi's arm, the gesture of someone managing a problem, not supporting a person. Think about it. She stood, walked away, left her scent of jasmine perfume and quiet threat behind. The ethics panel convened at 9:30. Naomi arrived early, took her seat in Section C, general admission, back half of the room, and opened her legal pad. The hall filled slowly. Faculty in the front rows. VIP guests in row A, their badges gleaming with distinction. Students and general attendees scattered through the remaining seats. At 9:45, Judge Kingsley Mercer took the podium. Good morning. His voice filled the room, confident, practiced. Before we begin, I want to address something. Naomi's pen paused. Some of you may have heard about an incident yesterday. A misunderstanding with an overeager student who doesn't understand that experience and credentials matter in our profession. Eyes turned. She felt them, curious, judgmental, amused. She kept her face neutral. I've been on the bench 17 years. I've seen young people who think reading a few case summaries makes them experts. It doesn't. It makes them dangerous. He paused, let the silence emphasize his point. Our profession requires humility. Some of us learn it. Some never do. Light laughter rippled through the room. Someone in row A nodded approvingly. Naomi wrote on her legal pad, "Public disparagement. Approximately 150 witnesses." 9:47 a.m. The panel continued. 3 speakers, Mercer, a local defense attorney, a law school professor, discussed judicial ethics for 45 minutes. Questions were invited. Mercer was answering a question about constitutional protections when he made his mistake. Every officer knows, the second the cuffs click, you read Miranda. That's constitutional law, not optional. Naomi raised her hand. The microphone runner, Fletcher Holt, she noted, hesitated. His eyes flicked to Professor Vane, seated in the faculty section. Some silent communication passed between them. Then he handed her the microphone. "With respect," she said, her voice carrying clearly, "Miranda v. Arizona requires warnings before custodial interrogation, not at the moment of arrest. The distinction matters. Berkemer v. McCarty, 1984, clarified that routine booking questions don't require Miranda warnings. Would you like the citation?" Silence. Mercer's face reddened. His jaw tightened. "I know what Miranda says. I've applied it more times than you've read it." "Then you'll recall Pennsylvania v. Muniz, 1990. Admissions during booking are admissible without Miranda warnings. Your characterization was imprecise." She handed the microphone back. The room buzzed. Behind Mercer, his clerk Cyrus typed furiously on a laptop, checking citations. "She's correct, Your Honor." The whisper was not quiet enough. Mercer's face went from red to purple. "We'll take a 15-minute break." The break had lasted 4 minutes when Cyrus Whitmore found her. That was quite a performance in there. Naomi stood near the water cooler, refilling her glass. She did not turn around. It wasn't a performance. It was a correction. Judge Mercer has a long memory. Cyrus stepped closer, lowering his voice. "You might want to consider your career trajectory before embarrassing sitting judges in public." Now she turned. "Is that a threat?" "It's advice, free of charge." His smile did not reach his eyes. "Law is a small world. People remember who made them look bad." He walked away, but not before she noticed him photograph her badge with his phone. The panel resumed. Mercer avoided eye contact with Section C. His answers became shorter, more guarded. The energy in the room had shifted. Something had cracked in the performance, and everyone felt it. At 11:15 the session ended. Applause, handshakes. The slow dispersal of an audience that would forget most of what they had heard by dinner. Naomi gathered her materials and headed for the dean's office. The receptionist was young, professional, unhelpful. "I'd like a copy of my original registration confirmation to verify my VIP status." "I'm sorry, that would require a formal records request. Takes about 2 weeks. I have the email confirmation on my phone. I just need you to verify it against your system. Our policy requires written requests for registration verification. Privacy concerns." Privacy. To verify her own information. "I'd like the written request form, please." The receptionist slid a 4-page document across the counter. The top line read, "Notarization required." Naomi took the form, did not argue, added it to her portfolio. Lunch was a sandwich from the campus cafe. eaten alone on a bench outside the library. The afternoon sessions held no interest. Networking events, career panels, the performative optimism of people who believed success was a matter of handshakes and business cards. At 3:47, her phone buzzed. An email from Fletcher Holt, Dean's Office. Date: Saturday, September 14th, 2024, 3:47 p.m. Subject: Registration status. Update. Dear Ms. Vance, upon review, we've discovered an irregularity in your registration. Your original VIP confirmation appears to have been generated in error. Our records show you registered as general admission on September 15th. We apologize for any confusion. Additionally, given concerns raised about your conduct at this morning's panel, the Dean has requested you refrain from participating in further Q&A sessions. This is not a disciplinary action, simply a request to ensure a productive learning environment for all attendees. She read the email twice. September 15th, tomorrow, a date that had not yet occurred. She opened her original confirmation email, September 3rd. VIP seating. The timestamp was clear, 9:47 a.m., 12 days ago. She took a screenshot, saved it to her phone and her cloud backup. Then she walked to the administration building. Hi. Fletcher was in the office, organizing files behind the reception desk. Your email says I registered September 15th. Naomi kept her voice level. I have the confirmation email from September 3rd with the original timestamp. Fletcher looked up. His face showed nothing, the practiced blankness of someone who had learned to lie without flinching. Email timestamps can be unreliable, server issues. You know how technology is. The email header shows your server's authentication, date, time, originating IP. That's not a glitch. That's a record. Something flickered across his face, surprise perhaps, or the quick recalculation of someone who had underestimated his opponent. I'm not a tech person. I just report what the system shows. He turned back to his files. Maybe you should take it up with IT. They're closed until Monday. She left, but she did not go back to her lodge room. The quiet room in the library was nearly empty at 4:30 on a Saturday afternoon. One student in the far corner, headphones on, laptop glowing. Otherwise, silence. Naomi found a seat near the window, opened her portfolio, began constructing a timeline. September 3rd, original registration confirmation received, VIP status, email authenticated via DKIM. September 13th, arrived on campus. Registration downgraded to general admission by Fletcher Holt. Told system glitch. September 13th, evening. Confrontation with Judge Mercer in lecture hall. B. Threatened with Dean's office complaint. September 14th, morning. Public disparagement during panel. Corrected legal error. Break. September 14th, 3:47 p.m. Email from Fletcher claiming September 15th registration date. Date impossible. Records altered. She photographed each entry, saved the images. At 6:47, the door to the quiet room opened. Bruno Caffey entered. Another security officer behind him, younger, uncertain. Ma'am, I need you to come with me. Naomi closed her portfolio slowly. On what basis? There's been a complaint. We need to verify your credentials. My credentials are verified. I've been on campus all day. Someone reported suspicious activity, unauthorized photography of registration systems. I took a screenshot of my own email, on my own phone. That's for us to determine. Caffey stepped closer. His hand rested on his belt, not on a weapon, but close enough to suggest the possibility. Please come with me or I'll have to escalate this. She stood, gathered her materials, moved without haste. I'll cooperate, but I want this documented. Your name, badge number, the specific complaint, and the name of the complainant. That's not how this works. Under Virginia Code Section 19.281, an officer must identify the nature of the complaint upon request during a detention. I'm requesting. Caffey blinked. The younger officer shifted his weight, uncomfortable. You a lawyer or something? I'm a registered attendee asking a lawful question. He did not answer, but the younger officer, his name tag read Marsh, pulled out a notepad. Maybe we should document this, Chief. Caffey's jaw tightened, but he nodded. Fine. Complaint came from Fletcher Holt. Said you were acting erratic, taking unauthorized photos, harassing staff. He crossed his arms. Happy? Thank you. I'd like that in writing. You'll get what you get. He grabbed her arm, not gently, and pulled her toward the door. The security office was a small room in the basement of the administration building. Fluorescent lights, plastic chairs, a desk cluttered with paperwork and half-empty coffee cups. Caffey pushed her into a chair, not hard enough to leave a mark, hard enough to make a point. Sit. She sat. Credentials. She handed over her badge. He examined it, typed something into his computer, frowned at the screen. System's slow on weekends. My badge has my name, registration number, and photo. Verification should take 30 seconds. System's slow, he repeated. You'll wait. She waited. 20 minutes. 30. At 7:15, she spoke. Am I free to leave? When we verify your status. You've had my badge for 28 minutes. The information is right there. System's slow. For the third time, like a mantra. She reached into her bag, took out her phone, opened the voice memo app, pressed record, set the phone on the desk, screen visible. I'm documenting this interaction. For the record, I've been detained for 29 minutes without being told the specific violation I allegedly committed. The complaint, per your statement, was erratic behavior and unauthorized photography, both of which are vague and, I believe, pretextual. Caffey's face flushed. Turn that off. Virginia is a one-party consent state. I'm the party. It stays on. He stared at her. She stared back. 35 minutes. 38. At 7:25, Caffey pushed back from his desk. You know what? You're free to go. He tossed her badge across the desk. It skidded to a stop at the edge. Don't let me catch you causing any more problems. She picked up the badge, clipped it to her cardigan. I'd like a copy of the incident report. There's no incident report. This was a courtesy verification. Then I'll file a public records request Monday, under the Virginia Freedom of Information Act. She walked out. The recording continued until she was outside the building, in the cool evening air, under a sky that had gone from blue to purple to black. Only then did she stop the recording. Only then did she let herself breathe. Sunday morning came gray and quiet. Rain tapped against the lodge windows, steady as a heartbeat. Naomi did not go to breakfast. She ordered coffee from room service, spread her documents across the bed, and began building her case. The email header from her original registration, received September 3, 2024, 9:47 a.m. Eastern Standard Time, from alumni registration at Whitfield, edu, authenticated via D. Kim's signature. Server, Whitfield Mail 01.virginia.edu. Fletcher Holt's email from yesterday, September 14th, claiming registration was September 15th, 12 days backdated. Server authentication inconsistent with original. The security log, she did not have a copy yet, but she had documented the detention. Time, duration, statements made. The public panel, approximately 150 witnesses to disparaging remarks. She photographed each document, uploaded them to 3 separate cloud accounts, emailed copies to herself and to one other address, her clerk at the 4th Circuit, with instructions to preserve the files. At 10:15 her phone rang. Judge Vance? The voice was female, older, familiar in a way she could not immediately place. This is Professor Martha Ellison, Constitutional Law, 1987 to 2019. I was in the audience yesterday when you corrected Kingsley Mercer. Naomi set down her coffee. Professor Ellison, I remember your torts seminar, spring of 2003. And I remember you, valedictorian, federal clerkship right out of school. A pause. I've followed your career. Your descent in Harmon V's State Board was exceptional. You're one of the few who's recognized me this weekend. That's because you're not wearing the robe or the title, and Kingsley Mercer has never been good at seeing past his assumptions. Another pause. I have something for you. Are you free this morning? They met in the campus coffee shop, a small space with mismatched chairs and the smell of fresh pastries. Professor Ellison was already seated when Naomi arrived, a manila folder on the table in front of her. I wasn't going to interfere. Ellison pushed the folder across the table. But after yesterday, I think you should see this. Naomi opened the folder, printed emails, an internal thread from the dean's office. Subject, registration issue, Vance. From Fletcher Holt to Professor Priscilla Vane. CC, Dean's Office. Admin date, Friday, September 13th, 2024, 8:15 a.m. Professor Vane, per your request, I've adjusted the Vance registration to general admission. The VIP confirmation has been archived but not deleted per legal retention policy. Let me know if you need documentation showing the error for her file. And Priscilla Vane's response, sent 4 minutes later. Thank you, Fletcher. Make sure Judge Mercer has the updated list for his panel introduction. We don't want any awkward surprises. Naomi read the emails twice, 3 times. They knew. Her voice was steady, but her hands were not. Before I arrived, they knew who I was, and they deliberately downgraded me. It appears so. Ellison's face was grim. The question is, why? What does Kingsley Mercer gain from humiliating a federal appellate judge? Maybe he doesn't know he's humiliating a federal appellate judge. Naomi set the papers down. Maybe he sees a black woman and decides the registry must be wrong. That would be the charitable interpretation. Ellison leaned back in her chair. The less charitable one is that he knows exactly who you are and wanted to remind you that in his world, credentials don't overcome other factors. Naomi looked at the email again, the timestamp, the casual cruelty of awkward surprises. How did you get these? I have friends in the dean's office, people who believe in accountability more than they believe in protecting benefactors. Ellison paused. There's more. She handed over additional papers. A campus security log, Saturday, 6:47 p.m. Entry by Chief B. Caffey. Detained female attendee for credential verification following complaint, suspicious behavior. Subject cooperative but combative. Released after 38 minutes. No formal report filed. Matter closed. Cooperative but combative. Naomi almost laughed. That's quite a contradiction. That's documentation designed to justify whatever story they need later. And finally, a printout from publicly available judicial conduct records. Judge Kingsley Mercer, Virginia Circuit Court, 17th Judicial District. 3 prior informal complaints filed with the Virginia Judicial Inquiry and Review Commission. All resolved with private admonishment. Subjects of complaints: 2 female attorneys, 1 black male defendant who alleged improper comments during sentencing. Private admonishment. Naomi's jaw tightened. No public record. That's how it works. Unless someone pushes it to formal proceedings. Ellison met her eyes. You're in a position to push, if you choose. Naomi gathered the papers, placed them in her portfolio. I choose. The closing ceremony was scheduled for 2 p.m. in the main auditorium. Naomi arrived at 1:45. The room was filling. Faculty, alumni, students, staff. The weekend's final gathering before everyone scattered back to their regular lives, their regular assumptions, their regular blindness. Dean Marcus Webb took the stage at 2. A thin man with silver hair and the practiced smile of an administrator who had learned to say nothing while appearing to say everything. Good afternoon. As we conclude this year's Alumni Symposium, I want to thank everyone who made this weekend possible. The speech continued. Sponsors acknowledged. Volunteers praised. The usual performance. And special thanks to our keynote speaker, Judge Kingsley Mercer, whose 17 years on the bench represent the very best of our alumni tradition. Applause. Mercer stood from his seat in the front row, turned to acknowledge the room with a wave. Before we conclude, we traditionally recognize distinguished alumni in attendance. This year, I'm told we have several notable guests. A figure rose from the faculty section, white hair, sharp eyes. Professor Martha Ellison approached the stage. "If I may, Dean Webb," her voice carried without a microphone, "I believe we've overlooked someone." The dean's smile flickered. "Professor Ellison, this isn't—" "Naomi Vance, class of 2004. Ellison turned to face the audience. "Currently serving as a judge on the United States Court of Appeals for the Fourth Circuit. She's been with us all weekend, in general admission, because someone decided her VIP registration was an error." Silence. Every head in the room turned towards Section C. Naomi stood. She did not rush, did not stumble, did not perform. From her bag, she removed her leather portfolio. Inside, her judicial credentials, the embossed seal of the Fourth Circuit Court of Appeals, gold on navy blue. "Good afternoon." Her voice filled the room. "I'm Judge Naomi Vance, Fourth Circuit. I've served on the federal appellate bench for 6 years. Prior to that, 12 years as a federal prosecutor. I clerked for Justice Harrington on this circuit after graduating from this law school, valedictorian." She let the words settle. "I came here this weekend because I was invited. VIP registration, row A. That registration was downgraded without my knowledge or consent. When I raised concerns about how I was treated, I was told I was erratic. I was detained by campus security for nearly 40 minutes. And I was publicly mocked, from that podium, by a man who assumed that because I wore a cardigan instead of a robe, I couldn't possibly belong in a room about judicial ethics." She turned, faced Judge Mercer directly. "Judge Mercer, for the record." She paused. Let the silence build. "The Fourth Circuit reviews appeals from Virginia state courts, including yours." Mercer's face went white. Behind him, Cyrus Whitmore dropped his pen. "Subscribe now, because what happens next will shock you." The room erupted, not in applause, in chaos. Murmurs became exclamations. Heads swiveled between Naomi and Mercer like spectators at a tennis match where someone had just set fire to the net. "I have documentation," Naomi's voice cut through the noise. She opened her portfolio, read aloud. "Email from Fletcher Holt to Professor Priscilla Vane. Date, Friday, September 13th. Quote, per your request, I've adjusted the Vance registration to general admission. The VIP confirmation has been archived, but not deleted per legal retention policy." End quote. She turned a page. Professor Vane's response sent 4 minutes later. "Thank you, Fletcher. Make sure Judge Mercer has the updated list. We don't want any awkward surprises." End quote. Murmurs rippled through the audience. Someone in the back row was recording on their phone. Campus security log, Saturday, 6:47 p.m. Chief Caffey's entry describes me as cooperative but combative. I was detained for 38 minutes based on a complaint from Fletcher Holt, who had 24 hours earlier altered my registration at Professor Vane's request. She looked at Priscilla Vane, seated in the faculty section. The woman's face had gone gray. Judge Mercer's judicial conduct history, publicly available through the Virginia Judicial Inquiry and Review Commission. 3 prior informal complaints, 2 from female attorneys, 1 from a black defendant who alleged improper remarks during sentencing. All resolved with private admonishment, no public accountability. Mercer stood. "This is outrageous." His voice shook, with anger or fear she could not tell. "You can't just—" "I can, and I am." She closed the portfolio. Under 28 U.S.C. Section 351, any person may file a complaint against a federal or state judge for conduct prejudicial to the effective administration of justice. I intend to file such a complaint. The materials will include this weekend's documentation, witness statements, and the pattern of prior complaints your commission chose to handle privately. Mercer stepped forward. His face was purple now, the vein at his temple throbbing. You think you can waltz in here and destroy my reputation based on what? A registration mix-up and some old complaints that went nowhere? I think the documentation speaks for itself. Documentation, he spat the word. You want documentation? How about the fact that you publicly embarrassed me in front of my colleagues? How about the fact that you've disrupted this entire event with your grandstanding? He was close now. Close enough that she could smell the rage on him, sour and sharp. I'll have you reported to the Judicial Council. I'll have you investigated for bias, for unprofessional conduct, for what? She did not step back, did not flinch. For standing in a room where I was registered to be, for correcting a legal error during a panel on judicial ethics, for documenting my own detention, for making a mockery of this institution. His hand shot out, grabbed her arm, hard, fingers digging into flesh. The room gasped. Let go of me. Her voice was ice. You think you're better than me? You think that robe makes you untouchable? His grip tightened. I've been on the bench longer than you've been out of law school. I've made decisions that shaped this state. And you're nothing. A diversity hire with a chip on her shoulder. Let go of me. Slower now, each word distinct. Or this becomes assault. Behind them, someone was calling campus security. Someone else was still recording. Cyrus Whitmore appeared at Mercer's elbow. Your Honor, please. His voice was urgent, panicked. There are cameras. People are filming. Mercer looked around, saw the phones raised, saw the faces, horrified, fascinated, recording every moment. He released her arm. She did not rub the spot where his fingers had left marks, did not acknowledge the pain, simply adjusted her sleeve and looked at Dean Webb, who had not moved from the podium. Dean Webb, I'll expect a response from your office by end of business Monday, regarding the altered registration records, the detention without cause, and the failure of your faculty coordinator to address documented misconduct. She gathered her portfolio. I'll also be contacting the Virginia Bar Association, the Judicial Inquiry and Review Commission, and, given the apparent coordination between your staff and a sitting state judge, potentially the Federal Bureau of Investigation. She walked toward the exit. Behind her, the room remained frozen. 200 people watching a world shift on its axis. At the door, she paused, turned. Judge Mercer, one more thing. She waited until his eyes met hers. Every appeal from your court that reaches the Fourth Circuit, I'll be recusing myself. Per 28 U.S.C. Section 455, judges must avoid the appearance of impropriety. But my colleagues will still review your work. Every decision, every ruling, every word. She smiled. I hope your legal citations are more accurate than they were yesterday. She left. The door closed behind her, and in the auditorium, Judge Kingsley Mercer stood alone at the front of the room, surrounded by witnesses, recorded on a dozen phones, watching his 17-year career begin to crumble. The drive back to Richmond took 2 hours and 12 minutes. Naomi did not turn on the radio, did not call anyone, did not process what had happened. She drove in silence, her portfolio on the passenger seat, her phone recording voice memos whenever a thought surfaced that needed documenting. At 4:47, her phone buzzed. A text from Professor Ellison. The dean called an emergency faculty meeting. Priscilla Vane has been asked to step back from her coordinator role pending review. Fletcher Holt's employment status is under discussion. At 5:15, another text. Mercer left campus immediately after the ceremony. His clerk was seen loading boxes into their car. The dean is reportedly considering options. At 5:52, a third message. Someone uploaded video of Mercer grabbing your arm. It's on social media. The law school's communications office is in crisis mode. Naomi pulled into her driveway at 6:23. The house was dark. She had not expected to return until tomorrow. She sat in the car for a long moment, let the engine idle, watched her hands on the steering wheel. They were shaking. Not from fear, not from anger. from the weight of what came next. She had won a battle. The war was just beginning. Monday morning, 9 a.m. Naomi sat in her chambers at the Fourth Circuit Courthouse in Richmond. The room was familiar. Bookshelves lined with case reporters, her desk organized with the precision of someone who had learned that chaos bred mistakes. On the desk, her portfolio from the weekend. The emails, the security log, the photographs of her bruised arm, taken Sunday night when the marks had fully bloomed. Her clerk knocked. "Judge Vance, the chief judge is on line 1. She picked up the phone. "Naomi." Chief Judge Harold Patterson's voice was grave. "I've seen the video. Are you all right?" "I'm fine. Some bruising, but nothing serious." "The commission's been notified. They're expediting the complaint review given the public nature of the incident." A pause. "You did everything right. Documentation, witnesses, restraint under provocation. It'll matter." "What about Mercer?" "State Judicial Conduct Commission is meeting this afternoon. The video complicates things, for him." Another pause. "There may be criminal referral. Simple assault, at minimum. That's a Class 1 misdemeanor in Virginia." "I'm not pushing for criminal charges, not yet. I want the conduct process to play out first." "Your call. But Naomi, the documentation you've compiled? It's thorough, more than thorough. You built this case like you were going to trial." She looked at her portfolio, the colored tabs, the time-stamped photographs, the email headers with their authentication signatures. "Habit," she said. "Old habit." Patterson was quiet for a moment. "Get some rest. The commission will reach out within the week. And Naomi?" "Yes?" "Good work. Not just the documentation, the restraint. He grabbed you in front of 200 people, called you a diversity hire, and you didn't lose your composure for a second." His voice softened. "That takes something. Don't let anyone tell you otherwise." She hung up, looked at her arm. The bruises were purple and yellow now, the shape of fingers clearly visible. She photographed them again, added the images to the file. Then she opened her laptop and began drafting the formal complaint. The formal complaint arrived at the office of the circuit executive on Tuesday morning at 9:14 a.m., 17 pages, 43 exhibits, a timeline that stretched from September 3rd to September 15th, 12 days that documented a systematic pattern of harassment, intimidation, and what Naomi's complaint called conduct prejudicial to the effective administration of justice. She had drafted it in her chambers over 2 sleepless nights, revised it 3 times, cross-referenced every citation, and verified every timestamp. Then she had printed it on her personal printer, signed each page in blue ink, and hand-delivered it to the clerk's office herself. No email, no intermediaries. Paper in hand, signature witnessed. The clerk, a young man named David who had worked in the office for 3 years, read the cover page and went pale. His eyes moved from the document to her face and back again, as if trying to reconcile the formal complaint in his hands with the composed woman standing before him. "Judge Vance, this is against Judge Mercer, the state court judge." "Yes." "The one from the video?" "Yes." He set the document down carefully, handling it like something fragile or explosive. "I'll process this immediately. The chief judge will be notified within the hour." "Thank you, David." She turned to leave. Behind her, she heard him reach for the phone before she had taken 3 steps. By the time she reached the elevator, she imagined the news was already spreading, through the courthouse, through the legal community, through the invisible networks that connected judges and clerks and attorneys across the state. Good. Let them talk. Let them wonder. Let them begin to understand that silence was no longer an option. By Wednesday, the video had been viewed 2 million times. Someone had uploaded it to 3 platforms simultaneously. The moment Mercer grabbed her arm, the words he spat at her, the way she stood motionless as he raged. The clip was 47 seconds long, 47 seconds that captured everything: the grabbing, the shaking, the purple-faced fury of a man who had never been challenged and could not process the experience. It had been shared by legal commentators, civil rights organizations, and news outlets from Virginia to California. The headline variations were predictable in their outrage. State judge grabs federal appellate judge at law school event, diversity hire. Judge's racist tirade caught on video. Federal judge reveals identity after weekend of harassment. Watch, moment arrogant. Judge realizes he attacked wrong woman. Naomi did not read the articles. She had learned long ago that public commentary, positive or negative, was a distraction from the work that actually mattered. Her clerk, a meticulous young woman named Teresa Chen, compiled summaries each morning. Relevant legal analysis only. No commentary, no social media reactions, no opinion pieces about what this meant for race relations in the judiciary. The state bar has opened a preliminary inquiry, Teresa reported on Thursday morning, setting a folder on Naomi's desk. Separate from the Judicial Conduct Commission, they're looking at potential ethics violations under Rule 8.4, conduct prejudicial to the administration of justice. Timeline? 6 to 12 months for the bar. The commission moves faster. They've already assigned an investigator. His name is Raymond Goss. 22 years with the commission. Solid reputation. Naomi wrote the name in her legal pad, added it to the timeline she was building, a document that grew longer each day, tracking every development, every response, every move and countermove in what was becoming a complex chess game. What about the university? Whitfield issued a statement yesterday afternoon. Teresa pulled a printout from the folder. Quote, Whitfield Law School is committed to fostering an environment of respect and inclusion for all members of our community. Following concerns raised at our September Alumni Symposium, we have initiated an internal review of registration procedures and staff conduct. End quote. Names? Fletcher Holt is no longer employed by the dean's office, effective immediately. Professor Priscilla Vane has stepped back from her coordinator role pending the review, but she's still on faculty. Campus Security Chief Bruno Caffey is on administrative leave. Naomi nodded. Expected outcomes. The institution protecting itself by sacrificing the lowest-level participants while preserving the structures that enabled them. Fletcher Holt had been the one to alter the records, so Fletcher Holt would be the one to take the fall. But the people who had given the orders, who had created the culture where such orders were thinkable, would face softer consequences. Reassignment. Leave. The quiet protection of tenure and position. It was accountability, but it was the shallow kind, the kind that made headlines without changing anything fundamental. Anything else? Teresa hesitated. Something in her expression shifted, the careful neutrality giving way to something more personal. There's been a request. From a journalist, Meredith Crane with the Richmond Herald. She's writing a longer piece about judicial accountability. She wants an interview. Decline, politely. I'm not commenting publicly until the formal proceedings conclude. I'll draft the response. Teresa gathered the folder, paused at the door. Judge Vance, for what it's worth, everyone in this office is proud of what you did, the way you handled it, the documentation. Naomi looked up, met her clerk's eyes. Thank you, Teresa, but pride isn't the point. The point is that it shouldn't have been necessary in the first place. Teresa nodded, left. Naomi returned to the brief on her desk, a Fourth Circuit appeal involving qualified immunity for police officers who had shot an unarmed man during a traffic stop. The irony was not lost on her. She was writing about accountability while living through a case study in how rarely accountability was achieved. She picked up her pen, got back to work. If you're still watching, hit subscribe. This story is just getting started. Friday brought Raymond Goss. He arrived at 10 a.m. sharp, a compact man in his 50s, gray at the temples, with the careful eyes of someone who had spent decades asking questions that people did not want to answer. His suit was charcoal, unremarkable, the kind of suit designed to fade into the background while the wearer observed everything. His handshake was firm but not aggressive, professional without being performative. Judge Vance, thank you for meeting with me. Mr. Goss, please sit. They were in a conference room adjacent to her chambers, neutral ground, recorded with her consent. Teresa sat in the corner with a laptop, taking notes. The windows looked out over downtown Richmond, late September sunlight falling across the polished table. Goss opened a leather folder. Inside, she could see copies of her complaint, the exhibits, the timeline she had submitted. I've reviewed your materials. He looked up. Thorough documentation. The email authentication alone would impress most forensic analysts. I wanted the record to be clear. It is. He turned a page. I have some follow-up questions, if you don't mind. Clarifications. Details that might help the Commission understand the full scope of what occurred. Of course. Let's start with the registration manipulation. You received your original VIP confirmation on September 3rd. The email from Fletcher Holt claiming you registered on September 15th arrived on September 14th, a date that hadn't occurred yet when the email was sent. Have you been able to determine how that error was made? I've requested the server logs through a FOIA request to Whitfield's IT department. The university has 60 days to respond, but their counsel has already indicated they may claim an exemption for records related to ongoing personnel matters. She paused. I suspect they're trying to run out the clock, hoping the public attention will fade before they have to produce anything incriminating. Goss made a note. His pen moved in small, precise strokes. The internal email chain, the one showing Professor Vane directed the registration change. How did you obtain that? A source within the faculty provided it. A professor who was disturbed by what she witnessed and believed accountability was more important than institutional loyalty. Naomi met his eyes. I've documented the chain of custody. The emails are authentic. I can walk you through the header analysis if you'd like, but I'm not disclosing the source's identity unless compelled by formal process. Understood. We may need to subpoena the original records from the university regardless. Corroboration will strengthen the complaint. He turned another page. The conference room was silent except for the scratch of his pen, the soft hum of the air conditioning, the distant sound of traffic from the street below. Let's talk about the security detention. 38 minutes. Chief Caffey's log describes you as cooperative but combative. Can you explain what happened during that time? Naomi walked him through it. The quiet room in the library, the two security officers entering without warning, the vague accusation of suspicious activity, the refusal to explain the specific complaint, the extended delay, despite having her credentials in hand, the moment she began recording. You cited Virginia Code Section 19.281 during the detention. That's specific knowledge for someone being detained without warning. I'm a former federal prosecutor, Mr. Goss. I spent 12 years memorizing statutes. It's not knowledge I can turn off simply because I'm not in a courtroom. A ghost of a smile crossed his face, the first crack in his professional neutrality. The recording, may I hear it? She pulled out her phone, opened the audio file, pressed play. Caffey's voice filled the conference room, dismissive and impatient, the voice of a man who had never been questioned and resented the experience. Her own voice came through flat and precise, asking questions he did not want to answer, citing laws he did not want to acknowledge. I'm documenting this interaction. For the record, I've been detained for 29 minutes without being told the specific violation I allegedly committed. Turn that off. Virginia is a one-party consent state. I'm the party. It stays on. The recording continued. The long silence. The shift in Caffey's tone as he realized this was not going the way he had expected. The abrupt release. You're free to go. Don't let me catch you causing any more problems. She stopped the playback. He released you immediately after you mentioned FOIA, Goss observed. He did. That's telling. He made another note. A detention that ends the moment the detainee demonstrates she knows her rights and intends to exercise them. Chief Caffey was comfortable detaining someone he believed to be powerless. The moment that assumption was challenged, his calculus changed. Goss studied her for a moment. Something shifted behind his eyes, not sympathy exactly, but recognition, understanding. Now, the confrontation at the closing ceremony. Judge Mercer grabbed your arm, called you. He checked his notes. A diversity hire with a chip on her shoulder. You have photographs of the bruising? She handed him a folder. 8 images, time-stamped, showing the progression from red marks to purple bruises to the yellow-green of healing tissue. These were taken over 4 days? Correct. The last image is from Tuesday morning. The marks have mostly faded now, but the photographs preserve the evidence. He examined each image carefully. His expression remained neutral, but she noticed his jaw tighten slightly as he looked at the clearest photograph, the one that showed the distinct impression of 4 fingers wrapped around her upper arm. Judge Vance, I have to ask you something. He set the folder down, met her eyes. Why didn't you reveal your identity earlier, when the registration was first downgraded? When Mercer confronted you in the lecture hall, you had opportunities to announce who you were. Why wait until the closing ceremony? She had expected the question, had prepared for it during the long hours of documentation, the sleepless nights of revision. Because I wanted to see how the institution responded when it believed I had no power. She paused. Let the words settle. If I had announced myself on Friday, shown my credentials, invoked my position, they would have corrected the error, apologized profusely, and nothing would have changed. The registration would have been fixed. Mercer would have been polite. Everyone would have congratulated themselves on how quickly they addressed the misunderstanding. And the next person, the next black woman who showed up without a title or a robe to protect her, would have faced the exact same treatment. Goss listened without interrupting. By waiting, I documented a pattern, the registration manipulation, the dismissal of my written complaint, the public mockery during the panel, the security detention. Each incident revealed something about how this institution and Judge Mercer treat people they perceive as powerless. Each incident created evidence that cannot be dismissed as a one-time mistake or a misunderstanding. She straightened in her chair. I am a federal appellate judge. I have resources, education, connections. I know how to document. I know how to file complaints. I know how to navigate systems that are designed to protect the powerful. Most people who face this kind of treatment don't have those advantages. They're silenced, dismissed, forgotten. So you used your position to expose something that usually remains hidden. I used my position to create a record. What the commission does with that record is up to you. Goss closed his folder slowly. Judge Vance, I've been doing this work for 22 years. Judicial conduct investigations. Most complaints go nowhere. Insufficient evidence, jurisdictional issues, political pressure, institutional inertia. The system protects its own. He stood, extended his hand. This one has teeth. Real teeth. The documentation is meticulous. The pattern is clear. Don't let anyone convince you otherwise. She shook his hand. I'll be in touch, he said. The preliminary review should be complete within 60 days. If we proceed to formal investigation, there will be depositions, document requests, possibly a hearing. Are you prepared for that? I've been prepared since September 3rd, Mr. Goss, whether I knew it or not. He left. Naomi sat in the empty conference room for a long time, looking at the folder of photographs she had not yet put away. The marks on her arm had faded, but the record remained. That was the point. That was always the point. The text message arrived on a Saturday evening, 3 weeks after the symposium. Naomi was at home, a modest townhouse in Richmond's Fan District, purchased 8 years ago when she was still a federal prosecutor making government salary. The house was comfortable without being luxurious. Bookshelves lined the walls. A small garden in the back, neglected now but showing signs of life. The kind of home that reflected a person who had never needed much, who had learned to find satisfaction in work rather than possessions. She was reading a novel, something light, a mystery recommended by her sister. trying to remember what it felt like to consume words that did not carry the weight of legal consequence. Her phone buzzed. Unknown number. Virginia area code. She almost ignored it. Spam calls were constant, and she had learned to let unknown numbers go to voicemail. But something made her look. Some instinct honed by years of prosecution, years of judging, years of knowing that important information often arrived in unexpected forms. Judge Vance. You don't know me, but I know what happened in 2019, with Mercer. Not the complaints you found, the one that was never filed. There's documentation. I wasn't ready to come forward then. I might be now. Will you listen? She read the message 3 times, 2019. 5 years ago. Before the complaints she had documented, the 3 informal complaints resolved with private admonishment, before the symposium, before any of it. Something older, something buried. She set down her book, typed a reply. I'll listen. When and where? The response came immediately, as if the sender had been waiting, phone in hand, hoping for exactly this answer. Not in person. Not yet. I need to know you won't disclose my identity without my consent. I need to know this won't disappear into the same system that protected him last time. I understand. What do you want me to do? A pause. 3 dots appeared on the screen. Disappeared. Appeared again. The digital equivalent of someone gathering courage. Check the 2019 Virginia State Bar disciplinary records. Look for a complaint that was filed and then withdrawn. The complainant's name will be redacted, but the case number should still exist. JC 2019-0342. That's where it starts. How do you know this? Another pause. Longer this time. Because I'm the one who filed it, and I'm the one they pressured to withdraw. Naomi stared at the screen. Her heart was beating faster now, the familiar adrenaline of a case breaking open, of evidence appearing from unexpected directions. I'll look into it. How do I reach you? You don't. I reach you when I'm ready. The conversation ended. Naomi set down her phone, picked it up again, set it down. Then she opened her laptop and began searching. The Virginia State Bar's online database was designed for public access, but not too much access. Disciplinary actions were searchable. Final orders were published. But withdrawn complaints existed in a gray zone, technically on record but practically invisible unless you knew exactly what to look for. JC 2019-0342. She searched for an hour, found nothing in the public database, no case number, no complainant name, no indication that the complaint had ever existed, but withdrawn complaints were not deleted. They were archived, and archives could be requested. She tried a different approach. The State Bar published quarterly reports, dry documents listing statistics on complaints received, investigated, resolved. Most people never read them. Naomi had read hundreds during her years as a prosecutor, looking for patterns, looking for gaps. She found the 2020 first quarter report, January through March, pages of statistics, charts, summaries, and buried in an appendix, a list of matters resolved without formal action. Case number JC 2019-0342, complaint against judicial officer, withdrawn by complainant, matter closed, no name, no details, no indication of what the complaint alleged or why it was withdrawn. But it existed. Someone had filed it. Someone had been pressured, the anonymous source's word, to withdraw, and Naomi now had a case number to pursue. Monday morning, 9 a.m. She called Raymond Goss. I need to add information to my complaint. There may be a prior incident from 2019 that was not included in the public record. What kind of incident? A complaint that was filed and then withdrawn. Case number JC 2019-0342. I don't have details yet, but I have a source who claims to be the original complainant. Silence on the line. She could almost hear Goss processing the implications, the expanded scope, the extended timeline, the pattern that stretched back further than anyone had known. Judge Vance, If there's a pattern extending back 5 years or more, I know what it means. Can you pull the original complaint file? I can request it. Withdrawn complaints are typically sealed, but the Commission has authority to unseal them for pattern investigations. It takes time, formal requests, judicial review, potential objections from Mercer's attorneys. How long? 3 to 4 weeks minimum, possibly longer if there's resistance. Do it, whatever it takes. I will. A pause. Judge Vance, this could change the scope of the inquiry significantly. If there's evidence of witness intimidation, obstruction of the disciplinary process, those are serious allegations, potentially criminal. I understand. I'll be in touch. She hung up, waited. The waiting was its own kind of work. Kyo. This is where it gets real. Like and subscribe. You don't want to miss what happens next. October became November. The leaves turned, brilliant reds and golds that painted Richmond's streets in colors that seemed too vivid for the gray reality of the investigation beneath them. Naomi continued her work. Oral arguments heard, opinions drafted, the endless rhythm of appellate review that demanded her attention regardless of what was happening in her personal case. She owed it to the litigants who appeared before her, the attorneys who argued their positions, the precedents that would shape law for generations. But beneath the surface, the investigation churned. Goss called twice with updates. The Commission had successfully petitioned to unseal the 2019 file. The original complainant, still anonymous, had alleged that Judge Mercer made inappropriate comments during a settlement conference. Comments about her appearance, her qualifications, her attitude, and nervous energy. Sound familiar? Goss asked. Very. There's more. The complainant was a young attorney, first year out of law school. She filed the complaint through proper channels, believing the system would work. And then, according to the notes in the file, she received a phone call from Judge Mercer's chambers. From Mercer himself? No, from his clerk at the time, a woman who called to explain why withdrawing the complaint would be in everyone's best interest. Who was the clerk? Her name was Dana Aldridge. She left Mercer's chambers in late 2019, left the profession entirely in 2020. Dana Aldridge. The name meant nothing to Naomi, but something about it nagged at her. Some connection she could not quite make. Then she remembered. The email chain from Whitfield, the one showing Professor Vane directed the registration manipulation. There had been a CC field, Dean's Office Admin, and in the version Professor Ellison had provided, part of a name had been visible before the cutoff. D. Ald. Goss. I need you to check something. The email chain from Whitfield, the one I submitted as Exhibit 17. There was a CC field partially visible. Dean's Office Admin, but the beginning of a name was showing before it cut off. D. Ald. Silence. You think Dana Aldridge is connected to the law school? I think it's worth checking. I'll look into it. Call you back. The connection came 3 days later. Goss's voice was tight with controlled excitement, the voice of an investigator who had found something significant. You were right. Dana Aldridge left Mercer's chambers in December 2019. She worked briefly in private practice, 6 months at a small firm in Norfolk, then left the profession. Or so it appeared. Appeared? She didn't leave entirely. She transitioned to university administration, started as an assistant in Whitfield's admissions office in 2021, promoted to assistant to the Dean of Student Affairs in 2023. Naomi closed her eyes. The pieces were falling into place, a picture emerging from fragments that had seemed random, disconnected. She was CC'd on the email chain, the one showing the registration manipulation. She was part of it, Goss confirmed. She knew about the registration change before you arrived. She was in the loop when Professor Vane directed Fletcher Holt to downgrade your status. And 5 years earlier, she was the one who called the young attorney and convinced her to withdraw her complaint against Mercer. It's a connection, direct, documented. We can prove she moved from Mercer's orbit to a position where she could continue protecting him. Naomi opened her eyes, looked out the window of her chambers at the Richmond skyline, a city that suddenly seemed smaller, more connected, more tangled in webs of loyalty and protection than she had imagined. What's her status now? Terminated, as of last week. Whitfield let her go as part of their internal review. But she's not cooperating with our investigation. Her attorney has indicated she'll assert Fifth Amendment protections if subpoenaed, which means she's worried about criminal exposure, which means there's something she doesn't want to say under oath. Naomi made a note, added Dana Aldridge to her timeline, drew lines connecting the dots, 2019, 2024, the complaint that was withdrawn, the registration that was manipulated, the pattern that stretched across 5 years and 2 institutions. What about my source, the original complainant from 2019? We're still trying to make contact. The file has her name, but it's sealed. I've reached out through intermediaries, attorneys who handled similar cases, advocacy organizations. If she's willing to come forward, I'll let you know. Thank you, Goss. Thank me when this is over. The source came forward on November 15th, not to Goss, to Naomi directly. Another text message, same unknown number. I'm ready. I've been watching the investigation, seeing Mercer's name in the news, seeing what he did to you. I can't stay silent anymore. Where do you want to meet? Not yet. I'm sending you a statement first. Everything that happened in 2019. You'll understand why I withdrew, and you'll understand why I'm not withdrawing again. The statement arrived by email an hour later. 12 pages, single-spaced, detailed. Naomi read it in her chambers, alone, the door closed, the phone silenced. The complainant's name was Iris Marlowe, 26 years old in 2019, first-year associate at a Richmond law firm. She had appeared before Judge Mercer for a routine settlement conference, a case involving a minor contract dispute, nothing controversial, nothing that should have been memorable. But Mercer had made it memorable. He had commented on her skirt. Too short for a courtroom, he said, though it fell below her knees. He had commented on her hair. Natural, worn in twists, which he called distracting. He had questioned her qualifications, suggested she was unprepared, implied that her firm had sent her because they did not care about the case. When she had tried to proceed with the conference, he had cut her off. Maybe you should let one of the senior attorneys handle this, someone who understands how things work. She had filed the complaint the next day, believed the system would work, believed that documentation would lead to accountability. 3 weeks later, Dana Aldridge called. The conversation was short. Aldridge spoke in the careful language of someone delivering a message, rehearsed, precise, designed to communicate threat without making explicit promises. Judge Mercer has friends in this state, Ms. Marlowe. Friends in the Bar Association. Friends on the disciplinary board. Friends who remember favors and repay them. If you pursue this complaint, those friends will remember you too, and not in a good way. Are you threatening me? I'm informing you of reality. You're new to this profession. You have loans, a career to build. Is this really the hill you want to die on? Iris Marlowe had withdrawn the complaint that afternoon, had left Richmond 6 months later, had rebuilt her career in another state, another city, trying to outrun the memory of what it felt like to be silenced. And now, 5 years later, she was ready to speak. Doug. Her formal statement arrived at the commission on November 18th, sworn, notarized, devastating. Goss called that evening. This changes everything. We're no longer looking at a single incident of misconduct. We're looking at a pattern extending back at least 5 years, involving witness intimidation, potential obstruction of the disciplinary process, and coordination between Mercer's chambers and the law school. What happens next? Depositions, document subpoenas. We're going to depose everyone. Fletcher Holt, Professor Vane, Bruno Caffey, Dana Aldridge, Cyrus Whitmore. The formal hearing is being scheduled for January. And Mercer? He's been notified. His attorneys are already filing motions, trying to limit the scope exclude certain evidence, delay the proceedings. Standard tactics. They won't work. No, they won't. Not with this documentation. December brought the depositions. They were conducted in a conference room at the Commission's Richmond office, windowless, fluorescent lit, equipped with recording equipment that captured every word, every pause, every moment of hesitation. Fletcher Holt went first. He appeared with a court-appointed attorney, his own resources exhausted, his position gone, his future uncertain. His face was pale, his hands unsteady, the confidence that had allowed him to dismiss Naomi's complaints now completely eroded. Mr. Holt, you altered Judge Vance's registration from VIP to general admission on September 13, 2024. Is that correct? Yes, I made the change. On whose instruction? He glanced at his attorney. The attorney nodded. Professor Vane, she called me that morning, said there was a situation with one of the registrations, said I needed to fix it. Did she explain what the situation was? She said Judge Mercer had reviewed the VIP list and had concerns about one of the names. She didn't say which name, but she gave me the registration number to change. Did you know who Judge Vance was when you made the change? A long pause. I looked her up. After Professor Vane called, I saw she was a federal judge, 4th Circuit. And you made the change anyway? Professor Vane said it had been approved. Said the dean's office had signed off. I was just following instructions. Following instructions to downgrade a federal appellate judge's registration based on the request of a state trial judge who would later physically assault her at your institution's event? His attorney objected. The objection was overruled. I didn't know what would happen. I didn't know. What did you know, Mr. Holt? I knew it was wrong. His voice cracked. I knew it was wrong when I did it, but I did it anyway, because I was afraid of what would happen if I didn't. Professor Priscilla Vane's deposition was different. She arrived with a private attorney, expensive suit, silver cufflinks, the kind of representation that signaled resources and connections. Her face was composed, her answers careful, every word measured against potential legal exposure. Professor Vane, you directed Fletcher Holt to alter Judge Vance's registration. Is that correct? I communicated a request from Judge Mercer's office to the registration team. I was facilitating, not directing. The email says, quote, per your request, I've adjusted the Vance registration. That suggests you made a request. A poor choice of words on Mr. Holt's part. Your reply says, quote, make sure Judge Mercer has the updated list. We don't want any awkward surprises. What did you mean by awkward surprises? Her attorney leaned in, whispered something. Vane nodded. I don't recall the specific context of that phrase. You don't recall writing an email 3 months ago? I write many emails, Mr. Goss. I don't memorize each one. But you remember directing Mr. Holt to change the registration? I remember communicating a request. From Judge Mercer? From Judge Mercer's office. Through Dana Aldridge? A pause, longer than the others. Ms. Aldridge may have been involved in the communication. I don't recall specifically. Ms. Aldridge, who previously worked as Judge Mercer's law clerk, Ms. Aldridge, who in 2019 contacted a young attorney named Iris Marlowe and pressured her to withdraw a complaint against Judge Mercer. That Dana Aldridge? Vane's composure cracked, just slightly, a tightening around the eyes, a tension in the shoulders that betrayed the calm facade. I was not aware of Ms. Aldridge's prior history with Judge Mercer. You hired her without knowing she had worked for the judge whose VIP list you were managing? The dean's office handled her hiring. I was not involved. But you were involved in coordinating with her to alter Judge Vance's registration? I've answered that question. You've avoided it. Let me try again. Dana Aldridge's deposition was the most revealing. She appeared with counsel, a nervous man from a mid-sized firm who objected to nearly every question, citing Fifth Amendment protections, attorney-client privilege, relevance, materiality, anything that might slow the extraction of truth. But the facts emerged anyway, in fragments, in admissions, in silences that spoke louder than words. Ms. Aldridge, you worked as Judge Mercer's law clerk from 2017 to 2019, is that correct? On advice of counsel, I declined to answer on Fifth Amendment grounds. Did you contact Iris Marlowe in 2019 regarding her complaint against Judge Mercer? On advice of counsel, Ms. Aldridge. Goss leaned forward. I have Ms. Marlowe's sworn statement describing the call. I have phone records showing a call from Judge Mercer's chambers to her personal cell phone on October 15, 2019. The call lasted 11 minutes. Are you telling me you don't recall that conversation? Silence. Her attorney whispered something. Aldridge shook her head. I may have made a call, in my capacity as Judge Mercer's clerk. What did you say during that call? Another whisper. Another headshake. I don't recall the specific words. Did you tell Ms. Marlowe that Judge Mercer had friends who could make her career difficult? I don't recall. Did you tell her that withdrawing the complaint would be in everyone's best interest? I may have suggested that the complaint was unlikely to succeed. On what basis? Judge Mercer told me the allegations were false. He said Miss Marlowe had misunderstood the situation. And you believed him? A pause. Long enough to matter. Long enough to reveal something beneath the careful denials and Fifth Amendment protections. I believed my employer. Do you still believe him? Her attorney objected. Relevance. Goss withdrew the question, but the answer was already written on Dana Aldridge's face, the face of someone who had spent 5 years protecting a man she knew did not deserve protection, and who was only now beginning to count the cost. Bruno Caffey's deposition brought a new revelation. He appeared in civilian clothes, the security uniform gone, the badge surrendered, the authority that had allowed him to detain Naomi for 38 minutes now stripped away by administrative leave and pending termination. Chief Caffey, you detained Judge Vance on September 14, 2024. Your log describes her as cooperative but combative. Can you explain what that means? She was cooperative in that she came with us when asked, combative in that she asked a lot of questions. Questions about the basis for her detention? Yeah. Questions she had a legal right to ask? His attorney shifted uncomfortably. I guess. Your log also says no formal report filed, matter closed. But Judge Vance requested an incident report. Why wasn't one filed? It was a verification, not an arrest. No report required. Who told you that? A pause. It's standard procedure. Whose standard procedure? Your department's? Whitfield's? Or someone else's? Another pause. Longer. I got a call, after the detention, from the dean's office, saying the matter was resolved and no report was needed. From whom specifically? I don't remember. Was it Dana Aldridge? His face tightened. I don't remember. Chief Caffey, I have phone records showing a call from the dean's office to campus security at 7:42 p.m. on September 14th, 15 minutes after Judge Vance left your custody. The call lasted 4 minutes. Do you remember that call now? Maybe. Things were hectic. During that call, were you instructed to delete security footage from the quiet room? His attorney erupted. His attorney. Objection. Assumes facts not in evidence. Calls for speculation. Let me rephrase. Chief Caffey, we have server logs from Whitfield's IT department showing that security footage from 7:05 p.m. to 7:15 p.m. was manually deleted on September 14th at 7:42 p.m., the same time as the phone call from the dean's office. The deletion was made using your credentials. Did you delete that footage? Silence. On advice of counsel, I decline to answer on Fifth Amendment grounds. Subscribe now. The hearing is about to begin, and everything is about to change. The Commission's formal hearing convened on January 14th in Richmond. The hearing room was austere, wood paneling darkened by decades of fluorescent light, a long table where the three-member panel sat in black robes. Not judges in the traditional sense, commissioners appointed by the state to review judicial conduct complaints, but the atmosphere was unmistakably judicial. The weight of consequence hung in the air, heavy as the silence before a verdict. Naomi sat at the complainant's table with Goss beside her. Her portfolio was open, the same portfolio that had held her registration confirmation 5 months ago, now thick with depositions, exhibits, sworn statements. Across the aisle, Judge Kingsley Mercer sat with his attorneys, 2 partners from a white shoe firm, their faces carefully blank, their presence a reminder that even the accused can marshal significant resources when their career is at stake. Mercer himself looked diminished. The confident posture from the symposium was gone, the chest-forward, space-occupying presence replaced by something hunched and wary. His eyes moved constantly, scanning the room, avoiding Naomi's gaze. The 17 years of authority had not prepared him for this, the experience of being judged rather than judging. The chief commissioner, a retired judge named Patricia Holloway, silver-haired and sharp-eyed, called the hearing to order. This proceeding concerns complaint number JC 2024-0847, filed by Judge Naomi Vance of the United States Court of Appeals for the 4th Circuit against Judge Kingsley Mercer of the Virginia Circuit Court, 17th Judicial District. The complaint alleges conduct prejudicial to the effective administration of justice under 28 U.S.C. Section 351, including but not limited to public disparagement, physical assault, racial discrimination, and obstruction of prior disciplinary proceedings. She paused. Let the charges settle over the room. We will hear evidence, examine witnesses, receive argument, and render a determination. Mr. Goss, you may present the complainant's case. The presentation took 6 hours. Goss was methodical, relentless, building the case layer by layer. The registration manipulation, the internal emails, the public mockery at the panel, the security detention, the physical confrontation. He played the audio recording from Caffey's office, Naomi's voice calm and measured against the security chief's dismissive impatience. He displayed the photographs of her bruised arm on a large screen, the distinct impression of fingers visible against dark skin. He read from the depositions, letting the witnesses' own words build the case against them. Then he introduced the 2019 evidence. Commissioners, the complaint before you is not an isolated incident. It is not a single lapse in judgment, a momentary loss of temper, a misunderstanding between professionals. It is the most recent manifestation of a pattern extending back at least 5 years, a pattern of harassment, intimidation, and systematic abuse of judicial power. He called Iris Marlowe. She entered the hearing room slowly, her footsteps echoing in the formal silence. She was older now than in 2019, 31, her face showing the years of carrying a secret she had been forced to keep. But her eyes were clear. Her voice, when she took the oath, was steady. Miss Marlowe, please describe your interaction with Judge Mercer in October 2019. She did. The settlement conference, the comments about her appearance, her skirt, her hair, her attitude, the dismissal of her preparation, her qualifications, her right to be in the room, the suggestion that she let one of the senior attorneys handle things. Why did you file a complaint? Because I believed the system would work. Her voice caught slightly, then steadied. I was young, idealistic. I thought if I documented what happened, if I followed the procedures, someone would hold him accountable. I thought the rules applied to everyone, even judges. What happened after you filed? I received a phone call from Dana Aldridge. She worked for Judge Mercer. Iris paused, gathered herself. She told me that if I didn't withdraw, my career would be over. She said Judge Mercer had friends, connections, people in the Bar Association, on the disciplinary board, who could make sure I never practiced law in Virginia. She said the complaint was baseless and would only hurt my reputation. Did you believe her? A tear slipped down her cheek. She did not wipe it away. I was 26 years old. I had $200,000 in student loans. I had just started my career, the career I had worked my entire life for, and a woman who worked for a sitting judge told me that if I didn't back down, that career would be destroyed before it began. She looked at the commissioners. I believed her, and I've regretted it every day since. Why are you coming forward now? Because I watched the video of what he did to Judge Vance. I watched him grab her arm, call her names, try to intimidate her into silence, the same way he intimidated me. And I realized something. She straightened in her chair. He didn't stop because I withdrew my complaint. He didn't learn. He didn't change. He just found new targets, and he would keep finding them, unless someone finally made him stop. The cross-examination was brutal. Mercer's lead attorney, a man named Harrison Webb, silver-haired and smooth, approached the witness stand with the careful confidence of someone who had dismantled testimony before. Ms. Marlowe, you waited 5 years to come forward with these allegations. Is that correct? Yes. During those 5 years, did you file any additional complaints against Judge Mercer? No. Did you contact the Bar Association, the Judicial Conduct Commission, or any other oversight body? No. Did you tell anyone about the alleged phone call from Ms. Aldridge? I told my therapist and my mother. But not anyone in a position to investigate? I was afraid. Her voice was quiet but firm. I explained why. You were afraid 5 years ago, but you're not afraid now? I'm terrified, but I'm more tired of being silent. Webb paused, changed direction. Ms. Marlowe, you left Virginia in 2020, moved to North Carolina, built a successful practice there. Is that correct? Yes. So, despite the alleged threats, your career was not destroyed. I destroyed it myself. I left Virginia because I couldn't stay in a state where a man like Kingsley Mercer held power over my future. I rebuilt somewhere else. But that doesn't mean the threats weren't real. It means I was lucky enough to escape them. Or it means the threats were never as serious as you believed. Objection. Goss rose. Argumentative. Sustained. Webb tried another approach. Ms. Marlowe, you have no documentation of the phone call from Ms. Aldridge. No recording, no transcript, no contemporaneous notes. Is that correct? I didn't record the call. I didn't take notes. I was in shock. So we have only your word that this conversation occurred? You have my word, and you have Dana Aldridge's deposition, where she admitted making the call. Webb's composure flickered, just slightly. He had not expected her to know about the deposition. Ms. Aldridge did not admit to making threats. She admitted to calling me. She admitted to discussing the complaint. She admitted to suggesting that withdrawal would be in everyone's best interest. Iris met his eyes. What would you call that, Mr. Webb, if not a threat? He had no answer. No further questions. The hearing continued into the evening. Witness after witness, document after document. The architecture of misconduct laid bare under fluorescent lights. At 6:30 p.m., Goss called his final witness. The complainant calls Judge Naomi Vance. Naomi rose, walked to the witness stand, raised her right hand and swore to tell the truth, an oath she had administered thousands of times, now reciting the words herself. Goss's examination was brief. The facts were already in evidence. He needed her voice to humanize them, to transform documentation into experience. Judge Vance, when Judge Mercer grabbed your arm at the closing ceremony, what did you feel? Pain. His grip was tight enough to leave bruises that lasted 4 days. She paused. But physical pain wasn't the worst part. The worst part was the recognition. I had seen that expression before, on defendants in my courtroom, on witnesses who had been threatened, on victims who had been silenced. It was the expression of someone who believed their power made them untouchable. And in that moment, facing a colleague who should have known better, I felt what every person without power feels when confronting someone who has it. the understanding that the rules don't apply equally to everyone. Why didn't you reveal your identity earlier? Because I wanted to see what the system would do when it believed I was powerless. If I had announced myself on Friday, they would have fixed the error and changed nothing. By waiting, I documented a pattern: registration manipulation, complaint dismissal, public mockery, unlawful detention. Each incident revealed how this institution, and Judge Mercer, treat people they perceive as beneath them. My position allowed me to expose what usually remains hidden. Most people who face this treatment don't have federal credentials to protect them. What do you want from these proceedings? Accountability, not revenge. Accountability. I want the record to show what happened. I want the system to acknowledge that Judge Mercer's behavior was not acceptable. And I want the next person he would have targeted, the next young attorney, the next woman who appeared in his courtroom without power or protection, to know that silence is not the only option. The cross-examination came from Harrison Webb himself. He approached the witness stand with the careful calculation of someone who knew he was facing a formidable opponent and was looking for any weakness he could exploit. Judge Vance, you've testified that you deliberately concealed your identity throughout the weekend at Whitfield Law School. Is that correct? I did not announce my identity. There is a difference between concealment and simply not volunteering information. But you allowed people to assume you were a student, a person without power or position. I allowed people to reveal their assumptions. Those assumptions were theirs, not mine. And when those assumptions led to conflict, when Judge Mercer reacted with frustration, he did not react with frustration, Mr. Webb. He grabbed my arm hard enough to leave bruises. He called me a diversity hire with a chip on her shoulder. He threatened my career. She leaned forward slightly. I am happy to show the commissioners the photographs again, if you need your memory refreshed. Webb changed direction. You filed this complaint during an election year. Judge Mercer is up for retention. Isn't it true that this complaint could affect his electoral prospects? I filed this complaint because a sitting judge physically assaulted me in front of 200 witnesses. I filed it because he has a documented history of similar behavior going back at least 5 years. I filed it because the system that should have stopped him chose to protect him instead. She met Webb's eyes. If that affects his electoral prospects, perhaps that says something about what voters believe is acceptable behavior in a judge. Isn't it possible that you're simply angry about being disrespected, and you're using your position to punish a colleague who failed to recognize you? No. No elaborate explanation? No justification? The evidence speaks for itself, Mr. Webb. I don't need to justify it. He had no follow-up. Closing arguments came at 8:45 p.m. The hearing room had grown dim. The fluorescent lights seemed harsher now, the shadows deeper, the exhaustion of a long day visible on every face except the commissioners, who maintained the careful neutrality their position demanded. Harrison Webb spoke first. 15 minutes of procedural objections, character witnesses, appeals to Judge Mercer's long and distinguished service to Virginia's judicial system. This complaint, he concluded, is the result of a misunderstanding that escalated beyond reason. Judge Mercer made assumptions based on appearance, assumptions that were incorrect. He reacted with frustration when corrected, frustration that was disproportionate but not criminal. He has served this state for 17 years with distinction. One incident, however regrettable, should not define a career. Then Goss stood. Commissioners. His voice was quiet, but it filled the room. Counsel asks you to view this as one incident, one mistake, one moment of frustration that went too far. He paused. But the evidence shows otherwise. This is not one incident. This is a pattern of harassment extending back at least 5 years, a pattern of intimidation, of witness tampering, of using judicial power to silence those who challenge it. He turned to face Mercer directly. In 2019, Iris Marlowe filed a complaint against Judge Mercer. She believed the system would work. Instead, she received a phone call from his clerk, a phone call that threatened her career if she did not withdraw. She was 26 years old. She was afraid. She withdrew. He turned back to the commissioners. In 2024, Judge Naomi Vance attended an alumni symposium at her own law school. She was treated as an intruder, a nuisance, a problem to be managed. Her registration was manipulated. Her complaints were dismissed. She was detained by security for 38 minutes based on a false report. And when she finally revealed her identity, Judge Mercer responded by grabbing her arm, calling her a racial slur, and threatening her career. He let the silence build. Judge Mercer has served 17 years on the bench. In that time, how many Iris Marlows have appeared in his courtroom? How many young attorneys have faced his comments about their appearance, their qualifications, their right to be there? How many complaints were never filed because the complainants knew what happened to those who spoke up? He sat down. This commission exists to protect the integrity of the judiciary, to ensure that those who wear the robe are worthy of the public's trust. Judge Mercer has demonstrated, repeatedly and conclusively, that he is not worthy of that trust. We ask that you hold him accountable. The Chief Commissioner adjourned the hearing for deliberation. The waiting was endless. 3 days. Naomi continued her work. The appellate calendar did not pause for personal crises. But the pending decision hung over everything. She drafted opinions with one eye on her phone. She attended oral arguments with half her attention elsewhere. The rhythm of judicial life continued, but it felt hollow, suspended, waiting for something to resolve. On January 17th, her phone rang. "Judge Vance, this is Commissioner Holloway. We've reached a decision. Can you be at the commission office at 10 a.m. tomorrow?" "I'll be there." Check. The decision was delivered in a formal session. The same hearing room, the same positions. Naomi at the complainant's table, Mercer across the aisle, the commissioners in their robes, their faces giving nothing away. Commissioner Holloway read from the written findings. Her voice was steady, measured, the voice of someone who understood the weight of the words she was speaking. In the matter of complaint number JC 2024-0847, the Commission finds as follows. She turned a page. With respect to the September 2024 incidents at Whitfield Law School, the Commission finds clear and convincing evidence that Judge Mercer engaged in conduct prejudicial to the effective administration of justice. His public disparagement of Judge Vance during the ethics panel, his physical contact with her person at the closing ceremony, and his use of racially discriminatory language constitute serious violations of Canons 1, 2A, and 3B4 of the Virginia Code of Judicial Conduct. She continued. With respect to the 2019 complaint filed by Ms. Iris Marlow, the Commission finds that Judge Mercer, through his then-clerk Dana Aldridge, engaged in witness intimidation by pressuring Ms. Marlow to withdraw her complaint. This constitutes an additional violation of Canon 2A and potentially implicates obstruction of the disciplinary process under Virginia Code Section 18.246D. She set down the page, looked at Mercer. Judge Mercer, the Commission imposes the following sanctions. The room held its breath. First, a formal public censure to be published in the Virginia Bar Journal, distributed to all Virginia courts, and entered into your permanent judicial record. Mercer's face went gray. Second, mandatory completion of a comprehensive judicial ethics training program, with verification of completion required within 180 days. His attorney whispered something. Mercer shook his head, a small defeated motion. Third, and most significantly, a formal recommendation to the Virginia Judicial Inquiry and Review Commission that removal proceedings be initiated. Given the pattern of misconduct extending over 5 years, the severity of the September 2024 incident, the evidence of witness intimidation in 2019, and the lack of remorse demonstrated throughout these proceedings, this commission believes that continued service on the bench is inconsistent with public confidence in the judiciary. Removal proceedings. Not guaranteed removal. The Inquiry Commission would convene its own hearing, review the evidence, make a final determination. But the recommendation carried weight. The pattern was documented. The evidence was clear. Judge Kingsley Mercer's 17-year career was effectively over. This is Justice. Subscribe now. The aftermath will shock you. Chapter 12. The aftermath unfolded in stages, each one revealing something new about how institutions respond when forced to confront their own failures. Within a week of the Commission's decision, Mercer announced his resignation. The official statement cited health concerns and a desire to spend more time with family. No mention of the censure, no mention of the removal recommendation, no acknowledgement of the women he had harassed, the witnesses he had intimidated, the system he had corrupted, the system protecting its own, even in defeat. But not everyone was protected. Whitfield Law School issued a revised statement 3 days after the Commission's findings became public. Following the conclusion of judicial conduct proceedings related to events at our September Alumni Symposium, Whitfield Law School reaffirms our commitment to dignity and respect for all members of our community. We acknowledge that serious failures occurred, and we have taken the following actions. Fletcher Holt. Employment terminated for falsification of records. Professor Priscilla Vane. Resigned from faculty, effective immediately. Chief Bruno Caffey. Employment terminated following investigation into evidence tampering and unlawful detention. Dana Aldridge. Employment terminated for conduct unbecoming a university administrator. Additionally, we have implemented new protocols for registration verification, complaint documentation, and campus security procedures. We have engaged an external consultant to review our policies and recommend further improvements. 4 terminations. 4 people who had participated in the harassment of a federal judge, and, if Iris Marlowe's experience was any indication, countless others whose names would never be known. It was accountability, partial, incomplete, insufficient, but real. The State Bar's inquiry concluded 2 months later. Mercer was found to have violated Rule 8.4 of the Virginia Rules of Professional Conduct, conduct prejudicial to the administration of justice. His law license was suspended for 2 years, with reinstatement contingent on completion of ethics training and a formal psychological evaluation. He would never practice law in Virginia again. Everyone knew it, even if the formal language left open a theoretical possibility. The criminal referrals were more complicated. Bruno Caffey was charged with evidence tampering, a Class 6 felony under Virginia Code Section 18.2-192. The server logs showed he had deleted 10 minutes of security footage 15 minutes after releasing Naomi from detention. His attorney argued technical malfunction. The prosecution presented testimony from the IT student who had discovered the deletion. The case was scheduled for trial in March. Dana Aldridge was charged with obstruction of a judicial proceeding, a Class 1 misdemeanor, based on her 2019 phone call to Iris Marlowe. Her attorney negotiated a plea deal. Guilty plea, 2 years probation, 200 hours community service. She would not serve jail time, but she would carry the conviction for the rest of her life. Mercer himself faced no criminal charges. The assault, grabbing Naomi's arm, was technically simple assault, a Class 1 misdemeanor with a statute of limitations of 1 year. The Commonwealth's attorney reviewed the evidence and concluded that while the conduct was deeply troubling, the penalties available under the criminal code were less significant than those already imposed by the Commission. It was a calculation Naomi understood. Sometimes the system worked best when it worked through its own channels. A criminal conviction might have felt satisfying, but the Commission's findings, public, permanent, devastating, had accomplished more than any misdemeanor conviction could have. Chowta. The letter arrived in late February. Naomi was in her chambers, reviewing a brief on voting rights, another case where power and accountability intersected, where the rules that governed democracy depended on people willing to enforce them. Teresa knocked. "Judge Vance? This came for you." Personal delivery. The courier said it was from Whitfield. Naomi took the envelope. Heavy cream paper. The law school's embossed seal. Inside, a handwritten letter on matching stationery. "Dear Judge Vance, I wanted you to know, I got the clerkship. When I applied, I wasn't sure you'd remember me. The law student who watched you stand up in Section C and identify yourself. The one who sent you a letter afterward, telling you it mattered. You wrote back. You said you'd remember. And you did. I start in August. I've spent the last 5 months studying your opinions, the ones you've written, the dissents, the concurrences. The way you write about justice, not as an abstraction, but as something that has to be fought for, documented, protected. I want to learn how to do that. I want to be the kind of lawyer who doesn't look away. Thank you for not looking away. Thank you for showing me what it looks like when someone with power uses it to protect the people who don't have any. See you in August. Iris Calloway, Whitfield Law School, Class of 2026. Naomi set the letter down, added it to her portfolio, the same portfolio that had held the registration confirmation, the email chains, the photographs of bruises now long faded. One person saw, one person understood, one person would carry the lesson forward. It was not justice, not completely, but it was something. March brought a new development. The investigation into Dana Aldridge's conduct had uncovered something unexpected. During her deposition, she had mentioned, almost in passing, that Judge Mercer had given her a list. Names. People in the Virginia Bar's disciplinary office. People in the Judicial Inquiry Commission. People who owed him favors. I kept it, she had said. Insurance, maybe, or guilt. But I kept it. The list had been subpoenaed as part of her plea agreement. 7 names. 3 were currently serving on state judicial oversight bodies. Raymond Goss called Naomi on a Tuesday afternoon. We have a problem, or an opportunity, depending on how you look at it. The list? The list. We've verified the names. 3 of them are exactly where Aldridge said they'd be. Positions with oversight authority over judicial conduct complaints. 2 have been there for over a decade. The pattern goes back further than anyone realized. What does that mean for Mercer's case? His case is closed. But it means his case wasn't the only one affected. If these people were running interference for him, they were probably running interference for others. We could be looking at dozens of complaints that were quietly dismissed, witnesses who were discouraged from coming forward, careers that were derailed because someone asked a favor. Naomi closed her eyes. The scope of it was staggering. Not one corrupt judge, but a network. A system within the system designed to protect power from accountability. What happens now? The state attorney general has opened a preliminary investigation. It will take months, maybe years, to unravel. Some of the people on that list have already resigned. Others are lawyering up. He paused. But it's happening. Because of what you documented. Because you didn't stay silent. The formal investigation into the network began in April. Naomi was not directly involved. She was a complainant, not an investigator, and her position on the federal bench required careful separation from state-level proceedings. But she followed the developments through Goss, through news reports, through the slow accumulation of evidence that revealed how deep the corruption ran. 2 of the 7 names resigned within weeks of the investigation becoming public. A third was suspended pending review. The remaining 4 hired attorneys and began the long process of defending themselves against allegations they had spent years believing would never surface. The Virginia Supreme Court appointed a special master to review judicial conduct complaints from the past decade, looking for patterns, for anomalies, for cases that had been dismissed too quickly or resolved too quietly. The review was expected to take 2 years. Justice, Naomi was reminded, moved slowly, but it moved. One evening in late May, Naomi received a final message. She was at home, the townhouse in the Fan District, the garden now showing the first signs of summer growth. She had spent the afternoon pulling weeds, turning soil, doing the kind of physical work that cleared her mind and reminded her that some things grew regardless of human intervention. Her phone buzzed. Unknown number. Different from any she had received before. Judge Vance. You don't know me, but I know what you did. I've been watching. There's another list, older than Dana Aldridge's, from before Mercer, before anyone thought to keep records. I wasn't ready before. I might be ready now. Will you listen? She stared at the message for a long time. The garden was quiet. The evening light was soft, golden, the kind of light that made everything look gentler than it was. She thought about what she had learned over the past 8 months, about power and silence, about documentation and persistence, about the slow, grinding work of holding systems accountable, work that was never finished, never complete, never enough. She thought about Iris Marlowe, who had waited 5 years to speak, about Dana Aldridge, who had kept a list for reasons she could not fully explain, about all the people who had stories they had never told, evidence they had never shared, courage they had not yet found. And she thought about what it meant to be someone who listened, who documented, who refused to look away. She typed her reply, "I'll listen." Then she closed her phone, set it on the garden table, and watched the sun sink below the tree line. 3 months later. August. Iris Calloway arrived for her first day as a judicial clerk. She was early, 20 minutes before the official start time, standing in the lobby of the Fourth Circuit Courthouse with a messenger bag over her shoulder and an expression that mixed nervousness with determination. Naomi met her at the security desk. "Ms. Calloway, welcome." "Judge Vance." Iris straightened. "Thank you. For everything. For the opportunity. For everything. Thank me at the end of the year, when you've seen what this work actually requires." They walked together toward the chambers, through corridors lined with portraits of judges past, through rooms where decisions that shaped American law had been made, through the quiet architecture of power that Iris was about to learn from the inside. "I've been studying your opinions," Iris said. "The dissent in Harmon v. State Board, the concurrence in Mitchell v. Commonwealth, the way you write about procedure, not as obstacle, but as protection. Procedure is protection, for the powerful and the powerless alike. The difference is that the powerful can usually find ways around procedure when it inconveniences them. Our job is to make that harder." They reached the chambers. Naomi paused at the door. "Ms. Calloway, you're here because you watched something happen and decided not to look away. That matters. But watching is the easy part. The hard part is doing, day after day, case after case, when the outcomes are uncertain and the resistance is constant." "I know." "Do you?" "I watched you stand up in Section C." Iris met her eyes. "I watched you document everything. I watched you wait. Not because you were afraid, but because you were building a case. And then I watched you use that case to bring down a system that had been protecting itself for years." She paused. "I don't know if I can do that, but I want to learn." Naomi nodded. "Then let's get to work." The new witness came forward in September. Her name was Catherine Hartwell. She had been a prosecutor in Virginia in the 1990s, before Mercer, before Dana Aldridge, before any of the names on the list that had finally been exposed. She had filed a complaint in 1997 against a different judge, a complaint that had disappeared into the system and never emerged. "I thought I was alone," she told Naomi during their first phone call. "I thought what happened to me was isolated. A bad judge, a corrupt system, nothing that could be changed. So I left. I left Virginia, left the law, rebuilt my life somewhere else." "What changed?" "I watched the news. I saw your name. I read about the investigation, the network, the list. And I realized I wasn't alone. I was never alone. There were dozens of us, maybe hundreds, scattered across decades, silenced by the same system that silenced me." "Do you have documentation?" "Some. Copies of the original complaint, notes from conversations, a letter from the investigator assigned to my case, explaining why the complaint was being resolved informally." She paused. "It's not much. 27 years is a long time, but it's something. Something is enough. Something is where it starts." The investigation continued. The Special Master's Review uncovered 16 additional complaints that had been improperly dismissed or resolved between 1995 and 2020. 8 complainants were located and agreed to provide statements. 3 had died. 5 could not be found. The State Attorney General's office filed charges against 2 of the 7 names on Dana Aldridge's list: obstruction of justice, conspiracy to interfere with judicial proceedings. Both cases were scheduled for trial in 2026. Judge Kingsley Mercer sold his house in Richmond and moved to a beach town in the Outer Banks. His wife filed for divorce. His name was removed from the Whitfield Law School building. The East Wing now bore the name of a different donor, one whose legacy was not tainted by censure and disgrace. His law license remained suspended. The 2-year period would expire in 2027. Whether he would seek reinstatement was unknown. Naomi did not think about him often. He had been a symptom, not a cause. The system that had protected him was the real enemy, and that system, for all its wounds, was still standing. But it was weaker now, more visible, more vulnerable to the slow, relentless pressure of documentation and exposure. That would have to be enough, for now. One evening in late October, Naomi sat in her chambers after hours, reviewing the latest batch of appeals. The work never stopped. Cases about immigration, about corporate liability, about the boundaries of executive power. Each one a puzzle, a challenge, a small opportunity to make the rules mean something. There was a knock at the door. "Come in." Iris Calloway entered, carrying a folder. "Judge Vance, I found something. In the Mitchell case files. A procedural anomaly. The district court missed a deadline that should have triggered automatic dismissal. But the case was allowed to proceed anyway. I think there might be grounds for reversal." Naomi took the folder, opened it, scanned the relevant pages. "You're right. Good catch. I almost missed it. It was buried in the appendix. But I remembered what you said. Procedure is protection. So I kept looking." "That's the job. Keep looking until you find what matters." She set the folder aside. "Anything else?" "Just..." Iris hesitated. "Thank you for teaching me, for showing me what this work looks like from the inside." "You're doing the work yourself, Ms. Calloway. I'm just pointing you in the right direction." "That's enough. That's more than most people get." She left. Naomi sat alone in the quiet chambers, surrounded by case files and legal volumes and the accumulated weight of a career spent trying to make the system work as it was supposed to. The work was never finished. The corruption was never fully exposed. The justice was never complete. But the record existed. The documentation remained. The pattern was visible now, to anyone who cared to look. And somewhere out there, in law schools and courtrooms and quiet offices across the country, there were people who had watched what happened in September 2024. People who had seen a woman in a cardigan stand up in Section C and refuse to be dismissed. People who had learned that silence was not the only option. That was the legacy, not the sanctions or the resignations or the criminal charges. The legacy was the people who would carry the lesson forward, who would document, who would persist, who would refuse to look away. Naomi closed the folder on her desk, turned off the lamp, let the darkness settle over the chambers. Tomorrow there would be more cases, more arguments, more opportunities to make the rules mean something. Tonight she would rest. The work would continue in the morning.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.